Items for delivery of judgment. Item 1, 6/7/2025, and item 2, 6,697 of 2025.
Both the petitions are allowed.
Item number 3 for admission.
Please, Lordship. Lordship, I beg to mention for urgent listing, Lordship, anticipated bail. The petitioner is an election observer, Lordship. So on today's his training and on 5th his counting is there. So Lordship, kindly heard the matter.
When do you want?
Lordship, it is anticipated bail. I need
When it is to be listed?
today, Lordship.
Today, how? Have you served notice upon the APP?
Yes, Lordship. Notice has been served.
But
Kindly, Lordship,
this is not, this bench is not taking the criminal matters now.
Lordship, it's an urgent matter because
Urgent matter, maybe. You go and mention, state the matter before the joint register. Because as per roster, I am not, this court is not entitled to deal with bail application. Except in those matters where this court has rejected the petition earlier.
But today's this court is there, Lordship. I have no other option left. because
This
it's
court
urgent.
cannot, unless authorized by the Chief Justice. You go and mention the matter before the joint register. If I am authorized, then no problem.
Lordship, I'm coming back, Lordship. Develop.
Item for admission. Item 3.
The other side is absent.
No, that is not appeared. They are not appeared. Notice received, notice bear last.
Okay,
That is why it is fixed today for this.
okay.
Here, my lord, the simple case is this: the petitioner filed a suit for declaration of right title in interest.
Mm.
They are in the absolute owner of the land. They possess the land by study. They allowed the defendants to permissive position to.
No, you, in the title suit, you were the
They are the defendant.
You were the
And I
defendant.
am the plaintiff.
You were the plaintiff.
Plaintiff. I filed a suit for declaration of right title interest
Interest.
eviction.
Yes.
We allowed them to reside in our lands for limited for 1 year. But after 1 year, they extended their construction. That is how we file a suit. And we also file an injunction petition. The London court below pass an order that both the parties to maintain the status quo. So it is okay. But they file an appeal, miscible before the civil judge. London civil judge has set aside that order of status quo. So now our land, admittedly, it is, if you also kindly see the order, page 44 of the order passed by the London Munship. He rightly decided the thing. He also
Page 44.
44. May I read?
Yes.
The brief fact of case is that the plot of land measuring so-and-so, total out of so-and-so, covered by so-and-so, situated local so-and-so, and another plot of land measuring 3 kata, covered by so-and-so, situated Lahori Pam Kisam under Lahori Kat Moja is the subject matter of the instant suit. One Bogiram Botole and Mohendra Botole were the original patratas of the suite pattern of so-and-so, containing 11 bigger so-and-so. They sold the entire plot of land to Abul Kalam, Samsuddin, Javed, and Ahmad Ali, who again sold the land to Wazuddin, who further sold the land to the Abul Kalam, Saidul, Firazuddin Khan. I am the Sirajuddin Khan, and Said Ali, Hafizuddin, and Kutubuddin. The petitioner plaintiff, Muhammad Sirajuddin Khan, passes 2 bigger so-and-so lessers from Ghiyasuddin, and says then he have been possession of the said land. The PP number so-and-so constitutes so-and-so dag number measuring 6 bigger 3 kata 4 lessers of land, and the petitioner plaintiff is the absolute owner in possession of the entire suite land.
Yes.
The petitioner plaintiff submit that the opposite party defendant have requested the petitioner plaintiff to allow them to decide over 2 katas of land covered by Dagno so-and-so situated at Laharipam, Kisam under Laharikat Moja in the district Morigao as permissive possession. The opposite party's defendant initially constructed a chali and had agreed to vacate the land after 1 year, but subsequently they extended their position over 5 kata of land. The petitioner plaintiff requested the opposite party defendant to vacate the land several times, but opposite parties defendant have started a permanent construction over the suit land. The petitioner plaintiff further submitted he is the absolute owner of the suit land and that the opposite parties defendant have no right title of the suit land. On receipt of notice, opposite party defendant was so appeared and filed written objection. The opposite parties defendants denied the amendment made by the petitioner plaintiff and stated that the petition is not maintainable but for non-zero of necessary parties. চাবা যেটা কথা কয় মোক কবা এটা কইলে কব লাগে এটা বহাত খায় কারণ কি যদি এটা কথা মোক কব লাগে
Yes.
On receipt of notice, opposite party defendant 173716 appeared and filed written objection. The opposite parties defendant denied the amendment made by the petitioner plaintiff and stated that the petition is not maintainable, but for non-zero of necessary parties, etc. The opposite parties defendant stated that the suit tag number so containing total land measuring 6 biga never belonged to the petitioner plaintiff, and that the opposite parties defendant have been in possession of the said land since 1974. And prior to that, their predecessors were in possession of the said land. The predecessor of the opposite parties defendant had dug a fishery over 1 biga Iman lands by dug number 119, and in the remaining land covered by dug number 429, they were doing cultivation. The petitioner plaintiff collectively with the help of Lat Mondal recorded his name as patadar of the land covered by dug number and Swenso without following the legal procedure, and hence the never required title land. Now it is important. On close perusal of the pleadings and the documents, it appears that the petitioner plaintiff has a prima facie case in his paper in that he claimed he had made in respect of the suit land and that he is the owner of the suit land is denied by the opposite party defendant, who stated that the predecessor of the opposite party's defendant were actual owner of the suit land, and after their death, the opposite party's defendants became the owner by way of inheritance. The petitioner plaintiff admittedly does not have possession over the suit land, scheduled land, though he claimed to have purchased the same by registered sale deed. In such a case, therefore, if the opposite party's defendants are not restrained by granting an order of injunction, he might cause great hardship. Situated thus, in view of the above discussion, the court deems it fit to grant an order of status quo. This is the order, my lord. Now that order has been challenged. The learned appellate court below, very mechanical manner, decided that the hypermacy case is in favor, balance of convenience also in favor of the defendant, and set aside that order, my lord. Page 48. Now his findings, my lord. Hello, page 51. Prima facie case. Last month. I perused the order passed by the learned court of Munship and found that the order has been passed very casually, without any discussion of the three golden principles. The Munship simply held that petitioner plaintiff admittedly does not have possession of the suit land, scheduled land, though he claimed to have purchased the same by registered deed. I also registered deed is there. In such a case, therefore, if the opposite parties' defendants are not restrained by granting an order of injunction, it might cause great hardship to the petitioner plaintiff, who has claimed to purchase the suit land. Situated thus, in view of the above discussion, the court deems it fit to grant an order of status quo in the position regard to the suit land till the disposal of the main suit. Both the parties are directed to maintain the status quo in this position with regard to the suit land and are restrained from changing the nature and future of the suit land till the disposal of the suit. The landed Munship failed to discuss the plaintiff petitioner would suffer for irreparable losses and injury, the Munship simply stated that the petitioner might suffer great hardship if injunction is not granted. Be that is as it may, having gone through the pleadings, I am of the considered view that the petitioner respondent has made a out of prima facie case as he contended that he is the absolute owner and possessor of the suit land, that the opposite parties are only permissive possessor, that the opposite parties refuse to vacate the suit land despite repeated requests. On the other hand, the opposite parties contended that they have been possessing the said land since 1974, and prior to that, their predecessors were in possession of the said land. The predecessor of the opposite parties' defendants have dug a fishery over 1 biga census of land, and in the remaining land covered by Dag number 429, they were doing cultivation. Thus, I find the petitioner has made out a prima facie case. This is the finding. So, admittedly, I have sold it. I purchased the land from the patadar, and we allow them to reside just for permissive possession. Now, this applicant held that he has a prima facie case because they are in possession since 1974. And how were they are come into possession of the said land matter? The balance of conventions. The learned Munship did not decide if the petitioner or the opposite parties would suffer great inconvenience. I, having gone through the pleadings of both the parties, found that the suit land is admittedly in possession of the suit lands. It is correct. Their land is in their position, my lord. Position. Though the petitioner claim that the opposite parties are permissive possessor, the opposite parties contending that they are owner of the suit land. Be that is it may, I am of the considered view that if the opposite parties' appellants are restrained from constructing structure of the suit, which they claim to be possessing since 1974, then they would suffer much greater inconvenience compared to any inconvenience that the petitioner respondent may suffer if the opposite parties' appellants are allowed to continue with any construction in the suit land. Restraining the opposite parties would be like restraining them from enjoying the suit land which they claim to be possessing, but there is no question of the petitioner enjoying the suit land as the same is presently not in his possession. Hence, I am of the view that the principle of balance of convenience in favor of the opposite parties. The learned Munship did not held if the petitioner would suffer irreparable loss or not before granting status quo. Considering the fact and circumstances, I am of the view that the petitioner would not suffer any irreparable loss or injuries if the temporary injunction is not granted. The structure, if any constructed by the opposite party civilian over the suit land, can be demolished and the petitioner can be compensated. This is the so better let the both party maintain a status quo. Now evidence stage, suit is in evidence stage, my lord. Now if they are create a permanent construction, there is a difficulty. So let the party maintain a status quo. Admittedly, I am not position. I am stated that they are in position. We allow them to possess. If the loss locally see the plaint, I clearly stated did not buy passes that is held it is there, my lord.
When did you purchase it?
Huh?
When did you purchase it?
It loss locally is a plaint, my lord. Plaint is page 13, my lord.
Yes.
Better. Paragraph 1, my lord. The plot for land measuring 2 kata out of total 11 biga, 1 kata 5 places covered by diagnosis census situated at Lahiri Palm Kisam under Lahirikat Moja, and another plot of land measuring 3 kata diagnosis census situated at Lahiri Palm Kisam under Lahirikat Moja in the district of Morigao, Assam, is the subject matter of the suit. The detailed description of total given value of the schedule. That originally the suit patta is belongs to Bagiram Botoloi and Mahendra Botoloi, constituting Dag number 171, and there are 11 bighas, 1 kata, 5 lesas of land in the Sweet Patta. Subsequently, they have sold the entire land to Abul Kasem, Abul Kalam, Samsuddin, Javed Ali, Hamid Ali, and they have sold the land to Wazuddin, and again Wazuddin has sold the land to Abul Kasem, Sohidul Islam, Sirajuddin Khan. I am the Sirajuddin Khan, my lord. Shaidul Khan, Habizuddin Khan, Kutubuddin. The plaintiff, Muhammad Sirajuddin Khan, has purchased 2 bighas of land to 1992, my lord. 331/1/1992, and also purchased 2 katas of land from Ghiyasuddin Sensu, and since then they have been possession. So 1992 we purchased, my lord. PP patta number 302 have constituting 4 ducts, so, and there are 6 bighas kata land, and the plaintiff Muhammad Sirajuddin Khan is the absolute owner in possession of the entire sweet land. It is his original owner, not purchased. That person of land is the original owner, 3 kata. That in the month of November 2018, the defendant requested the plaintiff to decide over 2 katas of land belonging to the plaintiff, as the defendant have no such residential land. Accordingly, the plaintiff allowed to reside them over 2 katas of land covered by Dag number 22, paper number 22, situated at Lahori, Pam, Assam, under Lahirigat Moja in the district of Morigao, Assam. Initially, they have constructed a Salighor and started to reside thereat. The defendant agreed that they would vacate the sweet land after 1 year, but subsequently, after completion of 1 year, the plaintiff requested the defendant to vacate the land, and initially they agreed to vacate, but now they have extended their possession over 5 katas of land and denied to vacate the said land. The defendant deciding that on permissive possession only, they have no right to the interest of the sweet land. That on 13/6/2020, the plaintiff requested the defendant to vacate the sweet land, but the defendant denied to vacate and threatened the plaintiff to cause death. The defendant started to construct. So this is the year in 1992. I have purchased the said land, and their written statement also there, my lord. They denied. Same thing there.
So then how the appellate court has found that the appellants are in possession of the suit land since 1974?
No document, nothing, my lord. No document. How can they are in possession, my lord?
Hmm?
We have a sale deed. We specific date. We mentioned the date of purchase. We mentioned, my lord. How can they got the position, my lord?
You see page number 53. Balance of
Yes, my
convenience.
lord. 53. Dam
From
London
the
Muslim,
middle,
my lord.
they claim to be possessing since 1974. From the middle, be that as it may, I am of the considered view that if the opposite parties' appellants are restrained from constructing structures over the suit which they claim to be possessing since 1974, they would suffer from great inconvenience compared to any inconvenience that the petitioner respondent may suffer. So this 1974, is it mentioned in their written statement?
They mention,
Okay.
but no document. How can they have become the owner? No, so that they simply mention illogistically their statement in paragraph.
Paragraph 15.
Yes, my lord. Paragraph, before that paragraph 13. 13. The suit is hit by relevant rules framed under Assam Land and Revenue Regulation Act 1986. The so-called issuance of PP Sensu are illegal and not binding. It is their claim, my lord. It is illegal. But they are not challenging it. They should have challenged it. They are not challenging it. Now we will also see paragraph 14. From the last part, District Morigao, as a cannot be the subject matter of the suit land. The dus paternal cannot be a subject matter, my lord. It is their claim. They claim that the contents made in paragraph 1 of the plaintiff is called baseless and same is denied by the answering defendant. The so-called two kata out of so-and-so, covered by so-and-so, situated Lahiripam under Lahiripam Maza in the district cannot be the subject matter of the suit. It is their claim, cannot be. Now, again, so-called three katas land covered by so-called so-and-so, situated Lahiripam under Lahiripam Maza district, Assam cannot be subject matter. If this is just a subject, not a subject matter, then what they will be suffer? Nothing will be suffered, my lord. Because since those land are not subject matter of the sweet land. Now let's see. The plaintiff totally falls on paragraph 15. Base same is not admitted by the answer defendant. The answer defendant in this regard begs to submit before this court that one Bogiram Badaloi so-and-so Abul Kasam Samsuddin were the original owner, suite number so-and-so, Dagno so-and-so, Lahiribam Kisam under Lahirikar was in the district of Morigao. The suite PP nong 16 contains as many as one duct, namely Dagno so-and-so, containing total area of 11 biga. Lessers. One Bogiram Bodoloi and Mohendra Bodoloi were the owner of one 5 lessers of land. Abul Kalam Samsuddin was the owner of 5 bigas of land. One Javed Ali and Hamid Ali, both Samusek, were the owner of 6 bigas of land out of 11 biga, 1 kata 5 lessers of land. All the opposite patatas during their lifetime had been possessing their respective share of land peacefully by paying land revenue to the gov regularly. One Javed Ali is the father of the answering defendant number 1, 7, 11, 16 and Hamid Ali. During the lifetime of Javed Ali and Hamid Ali, they jointly possessing their share of land, 6 biga of land, by paying land revenue to the gov regularly. In the meantime, in the year of 1974, one Javed Ali died, leaving behind the principal defendant number so-and-so. After his death, his legal heirs, namely answering defendant number so-and-so, inherited the land left by their father Javed Ali and have been possessing the 6 bigas of land jointly with their grandfather and Hamid Ali peacefully. In the year of 1983, one Hamid Ali died, leaving behind his legal heirs, and accordingly, after his death, his legal heirs inherited the share of land left by Hamid Ali. Both the legal heirs of Javed Ali and Hamid Ali have been possessing their share of land, 6 bigas of land jointly, peacefully, by paying land revenue to the government regularly. That both Javed Ali and Hamid Ali, son of Jomusek, were the illiterate person and they did not know how to read and write. After receipt of the summon in the above noted title suit, the answering defendant, as well as the legal heirs of Hamid Ali, made an inquiry before the Cycle Office Lahorigarh for obtaining certificate copy, and answering defendant were also made inquiry before the RKJ Morigao for obtaining certificate copy of relevant land record. After receiving the land record from both the office, it appears from the record that one Wazuddin, son of Umar Ali, collusively, behind the back and beyond the knowledge of the Javed Ali and Samid Ali, illegally mutated by of Chita, his name in record of right by so-called Chita mutation number so in place of Javed Ali and Hamid Ali as so-called possessor. Thou the so-called Wazuddin, collusively behind the back beyond the knowledge of the Javed Ali and Hamid Ali, mutated his name by of Chita mutation, but he could coverage to come into possession of the land of Javed Ali and Hamid Ali both son of so and so. The opposite cheetah mutation, even though passed collusively, but such type of fraudulent as well as illegal cheetah mutation did not cover any right title interest of to Wazuddin. So the Wazuddin did not acquire any right title interest to partial land of Javed Ali and Hamid Ali. But it is a fact that during the lifetime of Javed Ali and Hamid Ali, they had been possessing their respective shares, land 6 biga, land peacefully without any interruption. In the year of 1974, Javed Ali died. After his death, his legal heirs have been possessing the shares of land led by their father Javed Ali with Hamid Ali jointly. Again, in the year of 1983, Hamid Ali died, leaving behind his legal heirs, and since then the legal heirs of Javed Ali and legal heirs of Hamid Ali jointly possessing their shares land peacefully. What happened was that the so-called Wazuddin, son of Umar Ali, without any right, title, and interest, he illegally sold his so-called purchased land, 7 bigas to one Abul Qasem, one Saidul Islam. Even the Wazuddin illegally sold 7 bigas of land to one Qasem Ali and Saidul Islam. But the Said Wazuddin could not be able to deliver possession to the so-called purchaser. Thereafter, again, the said so-called Wazuddin, without having any right, title, interest over any portion of land covered by so illegally sold 2 biggest kata land to one Siraj Ali Khan. This is the. Whether they make any counterclaim, they'll not make any counterclaim here. Simply they stated that fact. So, my lord, my simple prayer, let the status quo be maintained with the parties to avoid the dispute.
Okay.
Wait. What's that?